It is now 10 o'clock and I would like to welcome you to this pre-examination meeting. Can everybody hear me? In the audience? Good. This meeting concerns the forthcoming inquiry into 5 applications submitted by Scottish Power Energy Networks, SPEN, for consent under Section 37 of the 1989 Electricity Act, undeemed planning permission under Section 57.2 of the Town and Country Planning Scotland Act 1997, to install and keep installed overhead electric lines described collectively as the Kendoon to Tongland reinforcement project in the Dumfries and Galloway Planning Authority area. My name is Katrina Rice and I'm a reporter in the Planning and Environmental Appeals Division. I've been appointed by Scottish ministers to hold the inquiry and report back all of the information to help them reach their decision. I will also make a recommendation based on my findings. First, some housekeeping matters. Given COVID restrictions, I would ask all those attending to wear face masks when moving around the venue or where physical distancing of 1 metre is unachievable. Please do not move the seating which has been arranged to conform with 1 metre physical distancing. There's no fire drill today, so if the alarm goes, please leave the room by the emergency exits to the left and here and assemble outside. Toilets are located down the corridor behind to your right. Please note that today's meeting is being filmed by my colleague Graham for live and subsequent broadcast via our website. Generally, the public seating areas will not be directly filmed. However, by entering the venue and using the public seating area, you are consenting to being filmed and to the use and storage of those images and sound recordings and any information pertaining to you contained in them for webcasting and training purposes and for the purpose of keeping historical records. And finally, please switch off all mobile phones or keep them on silent during the proceedings. Just to let you know that I am suffering a little with hay fever, so I may have to take a drink of water more often than normal. If I feel I'm going to start coughing, I will leave the room. Graham will stop filming until I return. Before we start, I would like to emphasise that the purpose and scope of today's meeting is purely to discuss the arrangements and procedures to be followed during and before the inquiry. This meeting is not part of the inquiry and I will not be discussing the merits of the proposal or hearing any evidence on the proposal today. I'll be keeping note of our discussions this morning and will circulate a note of the meeting which will set out all the procedural arrangements that we agree today. You should all have been sent a copy of the agenda, which gives an indication of the range of issues to be discussed. I have a few additional copies here if anyone requires a copy. There are also some at the back of the room. I also have an attendance list circulating around the room. I'd be grateful if everyone would sign this list before the end of the meeting by printing your name, address and, where appropriate, organisation. Finally, in order to enable everyone to hear the proceedings, I would ask parties to use the microphones provided. Press the button when you wish to speak and press it again to switch the microphone off. I will now invite the main parties to introduce themselves. I'll start with the applicant, then go to the council before moving on to others. So who is representing the applicant today?
Thank you. Thank you, ma'am. Good morning. My name is Miss Ailsa Wilson. I'm a Queen's Counsel at the Scottish Bar and I'm instructed by Mr Murray Thompson, who's sitting to my left, on behalf of SP Energy Networks. He's from Shepparton and Wedderburn, as I think you know. Do you wish to know who else is in attendance? Also in attendance is Mr Stephen Jack, who's the Environmental Planning Manager for SP Energy Networks. Mr Ross Baxter, who's behind me, is Head of Land and Planning. Mr Mark Peebles and Mr Scott Allison, who are both divisional solicitors with SP Energy Networks, and Mr Dan Walker from LUC, who's a landscape architect who's been involved in the scheme.
And who's representing Dumfries and Galloway Council?
Good morning, ma'am. My name is Peter Ferguson. I'm a partner with Harper MacLeod Solicitors and I represent the council.
And who's representing Scottish Forestry?
Good morning, ma'am. Andrew Kitching. I am the Woodland Technical Officer for Scottish Forestry for the South Scotland Conservancy.
And you're standing in today for Neil Murray, is that correct?
That's correct, but in the future it may be Doug Harrison as well, who's...
And what's his title?
Both of them are conservators for South Scotland Conservancy.
The other groups represented today, if we start with Mr Swift.
Paul Swift, probably the organiser for Galloway Without Pylons, just a community action group.
Thank you. And Mr John Thompson doesn't seem to have come today, so we'll move on to Mr McLean.
I'm Stephen McLean. I live in the village of Lauriston, about 9 miles east, which will be one of the communities that will be affected by this proposal.
Thank you, Mr McLean. Ms Harris.
I'm also a resident of Lauriston and also a member of Galloways Without Pylons and a retired ornithologist and conservation biologist.
And just for the records, we'll note that Laura Moody and Alistair Kerr have not come to the meeting today. Oh, sorry. Just come to the table. You see, your nameplate is on my right, your left. If you'd just like to introduce yourself.
Yep, I'm Laura Moody. I'm here from the Dumfries and Galloway branch of the Scottish Green Party.
Thank you. Mr von Spreckelsen.
Good morning, everybody. My name is Bernhard von Spreckelsen. I'm here in two parts, one representing my mum, who owns Sligari Estate, and the second part as the commercial rights holder to Sligari.
Sorry, could you just repeat that again?
Sorry. Sligari is an estate, a small farming estate. It's situated quite close to Lauriston, between Lauriston and Moscow. I'm here in a separate capacity because I'm developing a hyper-luxury project, and in an ideal world it would have part of it situated on Sligari.
So just a quick update on other parties who've been in touch. David Walden is not attending today, as he is happy to be represented by Galloway Without Pylons. Lady Beverly Vaux, Carol Boff, Margaret Glencross, Louise Cumberley, Andy McFarlane and Councillor Dougie Campbell have sent their apologies, and I received apologies for Gavin Chapman today. In total, 25 parties have notified us that they want to opt into the process. RSPB Scotland are upholding their objection, but have said they will be unable to take part in the inquiry due to capacity issues. Are there any other individuals here today who wish to participate in the inquiry? No? Finally, are the community councils represented by anyone here today? No.
Sorry, I should declare for the record, although I'm not here to represent a community council, I am a community councillor in Ball.
Thank you for that. In general, I strongly recommend grouping together with others who share the same point of view. This allows the presentation of a coordinated case, avoids any unnecessary duplication of effort, the repetition of evidence, and enables the pooling of resources. Going forward, I would encourage individuals and other groups of a similar view to join together and present a coordinated case. So, moving on to the application of the Code of Practice for Handling Inquiries under the Electricity Act 1989. There are no statutory rules relating to Electricity Act cases. The 1997 Town and Country Planning Inquiries Procedure Scotland rules have previously been applied by analogy, with all of the evidence presented at an inquiry being subject to formal cross-examination. However, the provisions of the Planning Scotland Act 2006 came into force in 2009. This changed and modernised the way in which the Planning and Environmental Appeals Division deal with planning appeal cases and planning applications called in by the Scottish ministers for their own determination. Amongst other things, these changes were intended to ensure that the procedures adopted in appeal and called in cases are proportionate and efficient, and that the process is transparent and fair. The Planning and Environmental Appeals Division is now seeking to apply the spirit of this approach to a wider range of casework, including cases such as this, which are proceeding under Section 37 of the 1989 Electricity Act. To that end, the Division published a Code of Practice for Handling Inquiries under the Electricity Act, updated in 2012. The code is available on our website, and I shall provide a link to that in the note of this meeting. I intend to deal with the inquiry in accordance with this Code of Practice. The approach provided for in the Code allows more flexible procedures to be adopted at this type of inquiry. In particular, it means that each issue identified for consideration can be dealt with by the most appropriate mode of examination, such as an inquiry session, a hearing session, or further written submissions. These further procedures are desirable where it is necessary for the reporter to gather further information on an issue or to have the evidence of parties explored or tested. On some issues, there will already be sufficient information in the material lodged, and no further procedure would be required. On this basis, I've gone through the papers already before me and have concluded that I have sufficient information on a number of issues, but that I need further information and evidence on others. We will look in detail at those issues where I consider I require further information under item 4 on the agenda. Our party is content if I follow the Code of Practice. Mr. Dunn.
Yes, ma'am.
Mr. Ferguson.
Yes, ma'am.
The next item on the agenda relates to the applicant's consideration of the individual representations received by the Energy Consents Unit during the consultation process. I have already asked the applicant, as part of their position statement, to provide a summary table of all representations together with their response to the representation. In response, the applicant has stated that many of the representations were in standard terms or raised very similar issues and themes. The applicant's response in their position statement was therefore related to these standard issues and themes rather than to individual representations. Having now read all of the representations, I recognise that many do follow a standard format. However, there are also a large number that do not, and which raise individual issues directly relevant to their particular circumstances. I will therefore require a response from the applicant, which makes it clear what the response is to each individual representation. This should take the form of a table, listing each representation by name and number. The response to representations which involve a standard wording can be grouped together, and the name numbers listed in an appendix. Where it is proposed that the issues raised will be covered at a hearing or inquiry session, this should be made clear. It should be obvious that all representations have been summarised and responded to by the applicant, particularly those which raise non-standard issues. I propose that the applicant should provide this consideration of the representations received within 2 weeks from today by 5 p.m. on the 29th of June 2022. Depending on your responses, I may have to amend the procedures for the inquiry and my note of this meeting, so as quick a response as possible would be appreciated. Ms. Wilson.
Thank you, ma'am. We have discussed this agenda item prior to today, and the general approach that we thought appropriate was to get from you today clarification as to exactly what it was that you were envisaging, because, as you know, there was a genuine belief, so far as my clients were concerned, that the way they had approached their position statement was logical and reflected also the analysis that they carried out when they received the different rounds of public consultation responses during the routing and alignment processes. Against that background, I've had some detailed discussions with Mr. Jack as to what would be involved if it was the case that you wished an analysis of all the individual representations and a response. I'm advised that the first step would be to check that all the representations are on the portal, because there have been complaints, as we understand it, from members of the public that their representations were not on the ECU portal. So to begin with, there would have to be some further investigation, probably with the DPA and also the consent unit, to check that we have access to the information to do that analysis. A lot of the representations didn't go separately to my clients, but were directed to the ECU. And I'm also informed that, so far as Dumfries and Galloway Council was concerned, it took a position that its role was not to act as a party involved in the consultation exercise, and that all representations sent to them should be sent to the ECU. So that is a matter that has to be clarified, that the source that's interrogated is full and accurate. That's going to take some time.
Can I just clarify that we received everything from ECU as well? So anything that we have, we got from ECU?
Well, the first step will be for those who will carry out this exercise on behalf of SP Energy Networks to check that they are interrogating a full database set, so that you can have confidence, as can the applicants, that the exercise that you wish carried out can be done. As of yesterday, Mr. Jack was making inquiries of the consultants who would carry out this exercise, who did the analysis on the consultation responses. And he'll have to go back and check, but as I understand it, even yesterday it was envisaged it would take a few weeks to get this done. We'll have to make further investigations and then report back to you, but I think I can confidently say, based on our discussions yesterday, it's not feasible that it will be done in 2 weeks.
It's not feasible. How long? Given that I have asked for this information twice already.
Well, ma'am, we simply weren't entirely clear just how detailed an analysis that was requested, because it seemed like a very large task, so it was considered appropriate to seek clarification today before that was instructed, to make sure the scope reflects your hopes and aspirations.
Thank you for that, but it would have been helpful if clarification was got before today.
It will be this afternoon before Mr. Jack can get confirmation as to the timescale that will be involved, but we'll relay that to your office as soon as it's available.
Thank you for that. But as I said, everything could change as a result of your comments on the representations. So as soon as possible is all I'll ask.
That's taken on board, ma'am, but we're also aware that we're facing a pre-examination meeting where we aren't sure the Council's position too, so there are a few unknowns, but we'll do our best to resolve the one within our power.
Thank you. Okay, moving on to agenda item 4, my provisional assessment of the main issues to be addressed, followed by a discussion around those requiring further procedure. The scope of evidence at the inquiry is clearly going to be related to the Council's views, consultation responses that have been received and letters of representation. At this stage, and based on my initial reading of the papers, the provisional list of the main issues which I will need to consider in my report in relation to the proposal are listed in Appendix 1 of the agenda. So it's a table. I'll just run through those quickly. Statutory context and national energy policy, national planning policy. Strategic route selection, design strategy and consultation. Justification for environmental impact assessment methodology. Technical justification for the project, economic justification for the project. Strategic alternatives including undergrounding, comparison of benefits, harms. Landscape and visual impact, including cumulative and sequential impacts, impacts of the on and off site access works and visual impact on residential amenity. Impact on forestry, development plan and other relevant planning guidance, both existing and emerging. Socio-economics, tourism and recreation impacts, traffic and transport impacts, particularly on residential amenity, impact on other nature conservation interests, including ornithology, intraconnection and intra-KTR effects, archaeology and cultural heritage impacts, including impact on setting, impact on hydrology, hydrogeology and water resources, including impacts on private water supplies, flood risk, water quality, fishing interests and groundwater-dependent terrestrial ecosystems, other construction impacts, including noise, impact on peat, impact on geology, EMF exposure and dust, and finally, any conditions and legal agreements required. Are there any issues which I've admitted and which should be added to the list, or is there anything which parties feel should be deleted? I will start with the applicant.
Thank you, ma'am. If I could start with the question of the needs case, technical justification for the project and economic justification for the project. The technical justification, as we understand it, would relate to system planning issues and why it is that this reinforcement is required and at the level that it's required.
Sorry to interrupt, but at this point I'm just listing those subjects which I'll cover in my report, not how I will cover them. So whether we'll have a hearing session, inquiring session, or who will participate will be next. It's just you agree that I will have to deal in some way in my report with all of those subjects. And is there anything that's missing or anything that I should take out? You're not saying that I should take out technical justification from my report?
Well, I hadn't got there yet, ma'am, but that is what I'm leading up to. I'm just getting clarification from yourself before I do so as to whether I'm correctly understanding what's meant by technical justification, which we consider is related to system planning issues and the need for the upgrade. And in that regard, so far as the applicants are concerned, we question the need for that session because of the fact that it's in MPF 4, well, presently in MPF 3 and now in MPF 4 as a national project. And in that regard, it would be our consideration that the needs case has been recognised by the Scottish Government because of the fact this project is identified as a national development. And therefore, we do question the need to include that topic at all. Similarly, with the economic justification for the project, that's a process that's followed through both by National Grid and also under the NOAA process and also Ofgem under its separate processes. So there are regulatory bodies, well, Ofgem being a regulatory body, who've examined it and have concluded that there is an economic justification for the project as designed in terms of its technical rating. So for reasons that I've explained, the applicant doesn't consider those two topics required to be within the agenda.
Thank you. And there's none that you would want added? Mr. Ferguson?
The agenda is fine as far as the Council is concerned, but as we will come on to, the Council would only intend to participate in certain of the sessions.
Mr. Kitching?
No, it's in there from a forestry point of view. No, there's nothing else to add to that from a forestry point of view.
Mr. Swift?
I'd just like to make a point about the justification, if I could. When we had a meeting with Scottish Power back in January 2018, they did say that it was to increase capacity. And now I understand, I mean, Stephen Jack will put me right if I'm incorrect, that there is no increase in capacity. So I do think that that does need to be investigated. Apart from that, no other issue.
Mr. McLean?
I think the agenda as it stands certainly covers my concerns.
Mr. Moody?
It's fine. I'm happy with the appendix as it is, but I agree with Paul's comments that I think technical justification definitely needs to be in there.
Ms. Harrison?
The agenda is fine by me, except, again, I would like to back up Paul Swift.
And Mr von Spreckelsen.
The agenda is great. I disagree with Sven's comments.
Anything else from the applicants?
Ma'am, ultimately it's a matter for you as to what reliance you place upon the fact it's a national development within the national planning framework in terms of the technical justification is concerned. But given the parties who have pushed back on the request that it be deleted from the agenda, as I understand it, aren't intending to lead expert evidence in rebuttal of what technical expert evidence the applicants might lead, that if you did consider it appropriate to hear some evidence or explore issues or give the third parties an opportunity to put their questions, such as the one that Mr. Swift put, which I'm advised by Mr. Jack is incorrect, this does increase the capacity, then a hearing session would be more appropriate because it's difficult to foresee that there would be cross-examination. I know I've jumped ahead, but that's my response.
Ferguson.
The council is content with the...
Sorry, I thought you cleared your throat as if you were going to speak. No, that's okay. And just to clarify, would any of the third parties intend to lead technical evidence on this issue? Mr. Swift, Mr. Kitching, Mr. Swift?
I'm not sure.
We'll discuss it more when we're looking at a hearing session or inquiry session, so that's okay. Sorry, Mr. von Spreckelsen.
I'm sorry to interrupt. The answer to your question is yes.
As I said, we'll discuss that further later in the agenda. Okay, so I will now outline my provisional assessment of the further procedures that I suggest we apply as set out in Appendix 1 of the agenda. I'll then hear your views on the procedures that I propose. I should emphasise that all of the written material already lodged, including the letters of representation, will be taken into account in any case. If I decide to deal with a particular topic on the basis of the material already submitted, that merely indicates that I have sufficient information on the topic and not that the issue is necessarily less important than the others. First, I do not propose any further procedure on other construction impacts, including noise, the impact on peat, the impact on geology, or EMF exposure and dust. I will be looking at noise as part of the conditions hearing session, but otherwise I consider that I already have enough information on these issues. I suggest that we have further written submissions to address areas of disagreement relating to, firstly, traffic and transport impacts. Particularly in relation to the comments of Transport Scotland dated November 2020 and September 2021, where they ask for some additional information in relation to the A75 crossing and their agreement or otherwise to the applicant's suggestion that this be dealt with by a planning condition. Also confirmation that the applicant agrees to the suggested council roads officer conditions. Secondly, impact on other nature conservation interests, including ornithology. In particular, I'll be asking for comments from Nature Scot on the RSPB Scotland objection contained in their responses dated the 18th of December 2020 and the 11th of May 2022. Also a response from the applicant to the mitigation measures proposed by RSP Scotland in their responses dated the 18th of December 2020 and the 11th of May 2022. Comments from RSPB Scotland on the positive aspects for ornithology of the proposed removal of part of the overhead line. and clarification from Nature Scott on what appropriate measures they are referring to in their suggested planning condition to minimise impacts on badgers, bats, red squirrels and pine martens. Also, how significant effects on Annex A and Schedule 1 birds beyond the SPA and SSSI qualifying features can be avoided by pre-construction surveys and the preparation of a bird managed protection plan. That's from Nature Scott's response dated November 2020. And finally, clarification from Nature Scott on the need for any updated surveys. Dependent on the responses received to the written submissions, I may then decide that a hearing session is unnecessary. Thirdly, interconnection and intra-KTR effects. I'll be asking for agreement from parties that the combined implications for residential properties can be dealt with under other issues, including landscape and visual impact, traffic and transport impacts, and planning conditions. Depending on the responses received to the written submissions, I may then decide that a hearing session is unnecessary. Fourthly, archaeology and cultural heritage impacts, including impact on setting. In particular, I'll be asking for confirmation that the applicant agrees to the suggested council archaeologist planning conditions. I'll be asking for council comments on the impact of the proposal on Category B and C listed buildings, which has not been provided by Historic Scotland. And also council comments on the applicant's response, which I'm hoping will be in 2 weeks, to impacts on any heritage assets referred to in representations. Then impact on hydrology, hydrogeology and water resources. Particularly the concerns expressed by the Galloway Fisheries Trust in their response dated the 20th of October 2020, and their agreement or otherwise to the preparation of a fish monitoring plan being the subject of a planning condition, as suggested by the applicant, and this resolving their objection. Also confirmation from the applicant that the other suggested planning conditions are agreeable, as set out in their Table 5. Finally, the Council's committee report provides summaries of the Council Access Officer, Landscape Architect, Archaeologist, Roads Officer and Flood Risk Management Team's responses. I'll be asking the Council to provide full responses. And I have a question. Does the Council have a biodiversity officer? Because there's no reference made in the committee report.
I don't know the answer to that, but I will quickly check.
One of the representations refers to a response from the then biodiversity officer to a scoping request consultation in August 2017. I'll be asking for a copy of that response. Next, I suggest that we have hearing sessions to discuss statutory context and national energy policy, national planning policy, strategic route selection, design strategy and consultation, justification for the environmental impact assessment methodology, development plan and other relevant planning guidance, both existing and emerging, socio-economics, tourism and recreation impacts, traffic and transport impacts, particularly on residential amenity, and conditions and legal agreement. I also suggest that if required, after further written submissions, we have a hearing session to address the impact on other nature conservation interests, including ornithology, and the interconnection and intra-KTR effects. Please note that at any hearing session on policy issues, in accordance with normal practice, parties should be allowed to express their views on how government policy should be interpreted, but they would not be allowed to question the merits of such policy. I should also point out that it is standard procedure to consider the planning conditions, and a discussion on these matters would not weaken the overall position of those participating in the session. Finally, I suggest that we have inquiry sessions which deal with the technical justification for the project, the economic justification for the project, strategic alternatives including undergrounding, comparison of the benefits and harms, landscape and visual impact. With regard to visual impact on residential amenity, I will initially be asking the applicant to explain how, in the absence of visualisations, I'm going to be enabled to make an assessment of the visual impact on the properties affected. This explanation will be requested as part of the further written submissions. And finally, impact on forestry. I would now like to hear the views of parties on the proposed procedures for each of these issues, including whether we should deal with the topics as whole line issues or there are any which need to also be discussed as local issues. So we'll start with the applicant.
Thank you, ma'am. In general terms, the applicant's content with your proposed procedures. And it's suggested that the first 5 topics that you have listed there are essentially whole line issues, which would take us down to strategic alternatives. And thereafter, the other issues are primarily local issues involving consideration in the localities. In terms of the hearing session, the applicant's content and particularly agrees with your approach of waiting to see the written submissions in certain of the topics before reaching a decision on whether a hearing session would be necessary. Would the applicants have the opportunity to give their views as to whether they felt anything did need to be explored by a hearing session once all parties' written submissions were available?
I hadn't envisaged that. Obviously, I would inform everybody of my decision, and then following that, if parties disagreed, they are welcome to provide their comments, but I hadn't included that in timetables at the moment, but I'll have a think.
Thank you, ma'am. And separately, in relation to the inquiry sessions, so far as the strategic alternatives are concerned, landscape and visual and impact on forestry, that coincides with the approach taken by the applicants in their position statement in relation to the environmental impacts, and accept that strategic alternatives should be looked at as in an inquiry session, as there's probably going to be contradictory views in cross-examination. In relation to landscape and visual impact, just responding to your comment in relation to residential amenity, we have had a discussion about this issue prior to today, and we'll be proposing to offer a residential amenity assessment as part of the inquiry evidence.
Thank you. At the moment, if you could just respond to my further written response, I will be asking for your position as part of the further written responses. Are you saying that as part of that you're going to provide additional information?
I'm just giving you advance notice, ma'am, that that decision's already been made, that work on that will start. You won't have to request it of the applicants. They'll volunteer it now.
And timescales?
Perhaps we could look at that, ma'am, where we set the procedural timetables for documents and see how it would fit into that. And then separately, I just renew the position in terms of the technical justification for the project, and that given the responses to my earlier submission to you regarding the lack of need for an inquiry session or indeed a hearing session, but the desire on the part of others to explore some issues related to the technical justification, for the reasons I've already given, I would suggest that should be a hearing session, and that there simply should be no further procedure in relation to economic justification unless you thought it appropriate to have any further written submission.
So technical justification by a hearing session, economic justification by further written submissions. Okay, Mr. Ferguson.
Thank you, ma'am. It may be helpful if I identify the topics which the Council intends to participate in and simply give our view on the appropriate procedure, because not all of the topics listed are relevant.
I'd prefer if you went through each of them and said whether you thought a hearing session or inquiry session would be relevant. You obviously know that I can invite you to a session, even if you don't want to take part in that session, if I feel I need points of clarification. So if you just go through, do you agree or not on my findings that there should be hearing sessions or inquiry sessions for the ones listed in the appendix?
On a topic-by-topic basis?
Yes. And we'll deal with your participation later.
With one exception, which I will come on to, the Council would agree with the proposed procedures.
And what's the exception?
And it's in relation to landscape and visual. And the Council's suggestion is that this should be a hearing session rather than an inquiry session.
And your reasons for that?
As things stand, the Council has not engaged external expert witnesses, and as things stand, evidence would be given by councillors. That position may change, however, we can only decide on procedure as things stand today, and given the likely participation of councillors in the session, we think that a hearing session would be more proportionate than an inquiry session.
Thank you. Mr. Kitching.
No, happy with everything that's on the agenda. Thank you.
Mr. Swift.
You're going to have to explain to me the difference between a hearing and an inquiry session, because I'm new to this, so you're going to have to take me slowly through it.
Yeah, I will go into a lot more detail about that later in the agenda, but just a very quick summary. A hearing session is basically an informal discussion. So we'd have a round table like this where the discussion will take place. I will lead that discussion. I'll also issue an agenda before the meeting. There'll be no formal cross-examination by advocates, so it is more of a discussion. Then the inquiry sessions are a formal process, so you'll have cross-examination rather than a discussion, and that will be led by the advocates. Does that help?
Yes.
So have you any comments on the proposed procedures?
No, no comments.
Mr. McLean.
I'm in a similar position to Mr. Swift. I'm not entirely clear what it is I'm being asked. I am anxious that myself, Paul and Nancy and other people who live locally and will be affected by this proposal have an opportunity to give further evidence. As to the exact form that takes, I'm unfamiliar with the process, so I'd be unable to really give an informed view at this stage.
I'm going to go on to speak about something which we call an evening session, so it may help if you listen to that as well. Okay, Mr. Moody, or Mrs. Moody.
I'm happy with it as outlined in the appendix.
I'm happy, but as you outline in the appendix, but if I could return to the nature conservation and ornithology, you helpfully went through some detail of what's become quite an amorphous topic of the elements, but I was waiting for the word mitigation. I'm not sure you had the word mitigation in that suite of things, and RSPB in particular had very specific recommendations, and I'd like the word mitigation to be in your lineup of topics there, if that's possible. Thank you.
One of the things I will be asking from the applicant is comments on the mitigation measures proposed by RSPB Scotland. But everything that I say today will be put in writing, so don't feel like you have to listen to everything that I say today. It will all be provided in the note of my meeting, but mitigation will definitely be in there. And I should say as well, I'll be asking for who wants to participate in all of these sessions. So if you say you want to participate, you will have the opportunity to comment on anything that's sent in by the applicant or Nature Scott. Okay, Mr. von Spreckelsen.
I have no disagreement with the way that you've set it out. I just would like to say that having got to this stage where things are being reviewed, I think it's very important that the applicant is made to put things in writing. And with a hearing session, that there could be the possibility that something is not disclosed.
Okay, I will be describing what happens before a hearing session and before an inquiry session. And just like at an inquiry session, we'll ask for inquiry statements. At a hearing session, we also ask for hearing statements. So don't feel everything will be in writing. And prior disclosure is really important, and no surprises on the day will be my key note. Okay? Okay, I did mention it there, but something else which I've used in the past to allow individuals to present their case without having to take part in a formal hearing or inquiry session is a separate evening session. Those attending would have the opportunity to make a brief statement, 5 to 10 minutes, about their concerns. Although both the applicant and the council would be present, there would be no cross-examination or questioning of those wishing to make a statement. The statements would not raise any new matters not previously raised in representations made about the application. No evidence of a technical nature would be included in the statements, for example, in relation to ornithology or traffic. Copies of the statements would be submitted 2 weeks before the evening session. And in the past, a community group has also provided a list of those wishing to attend and a timetable 2 weeks before the evening session. So do parties consider that an evening session would be appropriate or helpful for this proposal? Mr. Swift.
Absolutely. There are many people who would like to have come today but can't because they're working. So an evening session, I think, is absolutely essential.
And if it was run in the way that I outlined, that would be agreeable to you?
Agreeable, yes.
Mr. McLean.
Yes, agreed.
Likewise agreed.
Yes, agreed.
Perfect, thank you.
Mr. Ferguson.
Yes, ma'am. Given the level of public interest, an evening session seems entirely appropriate.
Ms. Wilson.
Ma'am, it's very much a matter for you. That's accepted by the applicants and will be in attendance as requested.
Okay, thank you for that very useful discussion. I'll consider your comments and will then come to a view to the best way forward, which I'll set out in the note of this meeting. If I do decide to have an evening session, in order to allow sufficient time to prepare, it would be on a day where there would be a formal hearing or inquiry session in the morning only, so nothing in the afternoon. So moving on to agenda item 5, participation of interested parties in further procedures. First, for written submissions. For those on traffic and transport impacts, I will be asking Transport Scotland, the applicant and the council to take part. Would any others like to take part? Mr. Kitching.
Not on those matters that you raised, no, with regards to those written submissions.
Mr. Swift.
Not that I'm aware of. I might think of something later on.
Yes, you will have the opportunity to opt in later on. Yeah. Mr. McLean?
No, not currently at the moment, no.
Nothing beyond our original submission, no.
No, nothing further.
Mr. von Spreckelsen.
Yes to everything.
For those on impact on other nature conservation interests, I'll be asking Nature Scot, the RSPB Scotland and the applicant and the council to take part. Would any other parties wish to take part? Mr. Kitching?
No. I suppose really the main thing with forestry covers that area as well, that our concern. With regards ancient woodlands, obviously it's a habitat by itself, so yeah, it's probably covered in the forestry section.
I think from memory the RSPB Scotland do mention forestry. So shall I put you down just in case you want to respond?
Yeah, it's probably worth adding us. Yeah,
Mr. Swift.
I just thought of three. The biosphere will be included, won't they?
In my note of the meeting, it will be sent to everyone who was invited to this meeting, and they'll be given, I think it's 14 days to respond if they want to be included.
Okay. Visit South West Scotland, have they been mentioned?
They haven't opted in, as far as I'm aware.
They haven't. And the South of Scotland Destination Alliance?
I've had a representation, but they haven't opted in, as far as I'm aware.
Okay, thank you.
Sorry, but do you want to be included in the nature conservation interests for the written submissions? I'm proposing some further written submissions on the nature conservation interests topic. Do you want to be involved in those further written submissions?
Oh, yes.
Yes.
Yes, I would.
Mrs. Moody.
Yes, please.
Mrs. Harrison.
Maybe in this case I should coordinate with Paul. Is that fine, Paul?
I'll put your name on the list anyway. And Mr. von Spreckelsen.
Yes to everything.
Next, for those on interconnection and intra-KTR effects, I intend to ask all of the parties here today to take part. For those on archaeology and cultural heritage impacts, including impact on setting, I'll be asking the applicant and the council to take part. Would any others want to take part? Mr. Kitching?
at the moment, possibly. Can you put it down as a yes? We can also opt out.
Mr. Swift?
Don't think so, no.
Mr. McLean?
No.
Mrs. Moody?
No, but can I ask whether the Galloway Glens Landscape Partnership have contributed in terms of the archaeology and cultural heritage?
I would have to check that. Could you name the group again?
Galloway Glens Landscape Partnership.
It doesn't ring a bell,
Okay.
but I will double check that.
Thank you.
Mrs. Harrison?
No.
And Mr. von Spreckelsen?
Yes.
For those on impact on hydrology, hydrogeology and water resources, I'll be asking the Galloway's Fisheries Trust, SEPA, the applicant and the council to take part. Would any others like to take part? Mr. Kitching?
Yes, but we can always obviously opt out if needs be.
Mr. Swift?
No.
Mr. McLean?
No.
Mrs. Moody?
No.
Mrs. Harrison?
No.
Mr. von Spreckelsen?
Yes.
There may be others from those who have submitted representations and who have indicated that they wish to participate. The full details of what would be required and those who wish to be involved in the further written submission procedures will be set out in my note of this meeting, which will be issued in due course. Moving on to the hearing sessions. For the session on statutory context and national energy policy, national planning policy, I would want the applicant, the council and Scottish Forestry to participate. Would any others want to take part? Mr. Swift?
Yes.
McLean?
No.
No.
Mrs Harrison?
Yes.
Mr von Spreckelsen?
Yes.
For the session on strategic route selection, design strategy and consultation, I would want the applicant, the Council and Scottish Forestry to participate. Would any others like to take part? Mr Kitching? Mr Swift?
Yes.
Mr McLean?
Yes.
Mrs Moody?
Yes.
Mrs Harrison?
No this time.
Mr von Spreckelsen?
Yes.
For the session on justification for the environmental impact assessment methodology, I would want the applicant, the Council and Scottish Forestry to participate. Would any others want to take part? Mr Swift?
Yes.
Mr McLean?
Yes.
Mrs Moody?
Yes.
Mrs Harrison?
Yes.
Yes.
Session on the development plan and other relevant planning guidance, I would want the applicant, the Council and Scottish Forestry to participate. Would any others want to take part? Mr Swift?
Yes.
Mr McLean?
No.
Mrs Moody?
Yes.
Mrs Harrison?
No.
Mr von Spreckelsen?
Yes.
For the session on socio-economics, tourism and recreation impacts, I would want the applicant, the Council and Scottish Forestry to participate. Scotways have said in their 2020 response that they did not have the capacity to take part in the inquiry at that time. Given the time that has passed since then, I also intend to ask Scotways if they still do not have the capacity to participate. Would any others want to take part?
Yes, please.
Mr McLean?
Yes.
Yes.
Mrs Moody? Mrs Harrison?
No.
And Mr von
Yes.
Spreckelsen? For the session on traffic and transport impacts, particularly on residential amenity, I would want the applicant and the Council to participate. Would any others want to take part? Mr Kitching?
No.
Mrs Swift?
Yes.
Mr McLean?
Yes.
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 No.
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 Mr von Spreckelsen?
Yes.
For the possible hearing session on other nature conservation interests, including ornithology, I would ideally want the applicant, the Council and RSPB Scotland to be represented, while recognising that RSPB Scotland has said they do not currently have the capacity to participate. Would any others want to take part?
No.
Mr Swift?
No, I'll leave that to Nancy.
Mr McLean?
No.
Mrs Moody?
Yes.
Yes.
Mr
Yes.
For the possible hearing session on interconnection and intra-KTR effects, I would want the applicant and the Council to be represented. Would any others want to take part? Mr Kitching?
Yes.
Yes.
Mr Swift?
Yes.
Mrs Moody?
Yes.
Mrs Harrison?
Yes.
Spreckelsen?
Yes.
Finally, moving on to the proposed inquiry sessions. For the sessions on the technical and economic justification for the project and the strategic alternatives, including undergrounding, I would want the applicant, the council and Scottish Forestry to participate. Would any others want to take part? Mr Swift?
Oh, yes.
Mr McLean?
Yes.
Mrs Moody?
Yes.
Mrs Harrison?
Yes.
Mr Bunce-Beckleson?
Yes.
For the session on landscape and visual impact, I would want the applicant and the council to participate. Would any others want to take part? Mr Kitching?
Yes.
Mr Swift?
Yes.
Mr McLean?
Yes.
Mrs Moody?
Yes.
Mrs Harrison?
Yes.
Yes.
Finally, for the session on the impact on forestry, I would want the applicant, the council and Scottish Forestry to participate. Would any others want to take part? Mr Swift?
Yes.
Mr McLean?
No.
Mrs Moody?
Yes.
Mrs Harrison?
No.
Mr Freckleson?
Yes.
For the possible evening session, I would want the applicant and the council to be represented, although they wouldn't take part. I don't know if you'll know names at present, but would anyone know who would like to take part in the evening session? So that would be a 10-minute talk.
I know several.
So I'll put in my note, if you could provide me with a list within a certain time scale, that would be really helpful.
Yep,
Would anyone else like to add to that list?
I'm sure one of the local business people from Lauriston, Phil McMenemy, would like to participate, but he's more than likely on Paul's already existing list.
Mrs Moody?
Yes, I might have a couple of people who would want to speak who aren't already on Paul's exhaustive list.
Mrs Harrison?
Again, I think Paul has the definitive list.
Mr Bunce-Beckleson?
I have no one to add. It's just myself.
So you want to take part in the evening session
Yes,
as
please.
well as the hearing and inquiry sessions?
Yes, please.
So if I could ask everyone to liaise with Mr Swift, who will provide me with a list of names, and I'll give you the time scale for that, and then we'll be in touch further after that. On the procedures that I've outlined, Mr Ferguson?
No, ma'am.
Ms Wilson?
No, ma'am. Thank you.
Six, the hearing of evidence. So I'll now give a brief outline of the procedures to be followed for hearing evidence at the inquiry and hearing sessions. For hearing sessions, as I've said previously, this will take the form of a structured discussion between the parties involved, which I will lead, and at which no cross-examination will be permitted. All paperwork will be taken as read and the discussion will start from there. For inquiry sessions, the order for hearing evidence will be the applicant, any supporters, the council, if participating, then other consultees, then individual objectors. Each party appearing will be invited to present evidence in chief, which can be subject to cross-examination by those of an opposing view, following which there will be an opportunity for re-examination. Friendly cross-examination between parties on the same side will not be permitted, but questions of clarification are acceptable. Irrelevant or repetition evidence or cross-examination won't be permitted. Parties will be invited to make closing statements after the evidence has been heard. These are provided in writing. They will be lodged in the same sequence as if they were being presented orally. So the individual objectors, any consultees, the council, then any supporters, and finally the applicant. They would also be circulated to those parties presenting closing statements and posted on our website. We would agree the dates for submission at the end of the inquiry. If any party is considering making legal submissions that could affect the running of the hearing and inquiry sessions, please lodge them as soon as possible and do not wait until the start of Delaying any such legal submissions is contrary to the spirit of prior disclosure, wasteful of expensive inquiry or hearing time, and unfair on other parties. So next, dates, location and likely duration of the inquiry hearing sessions. So we need to consider how many days they could last. So I've approximated half a day for the hearing sessions, and I thought 2 days for the inquiry sessions. So I'd like to ask parties' views on the likely duration and the order in which the sessions ought to be held. First, the 9 hearing sessions. How many days do you think they would last? And would there be any scope to combine the issues to be dealt with in a lesser number of hearing sessions? First of all, the views of the applicant. Ms Wilson.
Ma'am, if I could just have a minute based upon the discussion we've had.
I was actually going to say people welcome a 10-minute comfort break because we have been talking for quite a while, and that will give you the opportunity to have a think. So we'll adjourn for 10 minutes and we shall start again at, say, 11:20. Thank you. Take a seat. Thank you. Mr. Swift. First of all, I'd just like to ask Mr. Kerr to introduce himself. He was unfortunately sitting in the audience, but he is a participant, so just introduce yourself, Mr. Kerr.
Unfortunately, I wasn't quite aware that I was invited to the top table. I stay in Galloway Forest Park, so I'm a householder and a member of Galloway Without Pylons.
And your participation in the proceedings, do you still want to take part in everything, or would you be welcome that Mr. Swift would represent your views?
I'm happy to be involved in proceedings.
I will invite you, but obviously when you read what's required, if you don't want to be involved in everything, just let us know in the usual way.
Right, appreciate that. Thank you.
So we're on agenda item 7, which is dates, location and likely duration of the inquiry hearing sessions. First, the 9 hearing sessions. So how many days do you think they would last, and would there be any scope to combine the issues to be dealt with in a lesser number of hearing sessions? Ms Wilson.
Ma'am, as far as your estimate of half a day is concerned for each of the hearing sessions, we generally agree with that, with the possible exception of the second item, strategic route selection, design strategy and consultation, and also socioeconomics, tourism and recreation, just with the number of other parties who have indicated they want to participate at the level of interest in those topics. So for both those topics, we would suggest perhaps it would be safest to allow a day, even if a full day is not used. But in relation to the other topics, it is possible that half a day could be allowed. And in terms of combining issues, it would seem sensible to combine statutory context, national energy policy, and planning policy with development plan policy.
You did say earlier, though, that the statutory would be a whole line issue, whereas the development plan would be local issues.
Yes, I was thinking, ma'am, if they were being combined, we could perhaps have the morning on national policy and whole line and then move seamlessly into development plan policy in the afternoon. And so that is, we calculated it would be 5.5 days time for hearing sessions. And then in relation to the inquiry sessions...
Sorry, but can we just deal with the hearing first and then we'll go on to the inquiry? Mr. Ferguson.
Yes, ma'am. I broadly agree with Ms Wilson that half a day is generally sufficient, but in this case there could be some overspill. It's difficult to predict which of the individual sessions may go beyond half a day, and if my counting is correct, there are 6 hearing sessions plus 3 provisional. But for the 6, I would estimate between 3 and 5 days.
Thank you. Mr Kitching?
Again, it's difficult to predict, but I would say that's sufficient.
The longer timescale proposed by the applicant or my shorter?
Sorry, the one that you've proposed.
Mr Swift?
Well, you won't be surprised to know that I haven't got a clue. So I'm just happy to take advice from learned people on the table here.
Thank you, Mr Swift.
Okay.
Mr McLean, have you anything to add?
I'm in the same position as Mr Swift. I'd be guided by people who are more experienced, not having taken part in an inquiry of this nature previously, so I'm not able to give a view as likely duration.
Mrs Moody?
I think slightly longer sessions are probably more likely than shorter, but I'm happy with your proposals as outlined.
Mr Kerr?
Happy to take advice from those in the know.
Mrs Harrison?
Yeah, your schedule sounds fine.
Mr von Spreckelsen?
Your original schedule.
Okay, then we'll move on to the 5 inquiry sessions. How many days do you think they would last, and would there be any scope to combine the issues to be dealt with in a lesser number of inquiry sessions? Ms Wilson?
Well, in relation to the technical and economic justification, without departing from my original position earlier this morning, in relation to both matters, if you consider it appropriate to have inquiry sessions for those topics, they could be combined in one day, I would have thought. Separately, in relation to the other topics, I think your suggestion of 2 days per topic is appropriate. There may be, all that time may not be required, but if we've got some flexibility in the programme and run on, it's easier to finish early than try and find new dates.
Mr Ferguson?
I don't have a feel for the extent of the evidence in the technical or economic justification sessions, and I would be guided by Ms Wilson on that. But again, 2 days is generally a good rule of thumb for full inquiry sessions. I suppose that the other scheduling point is if there is going to be an evening session with a gap in the afternoon, then that's going to add an extra half a day or a day to the programme.
Yeah, from experience, having an evening session following 2 sessions in the morning and afternoon is quite taxing, not just for us, but for the participants as well. So I would prefer to have that break. Mr Kitching?
Again, yeah, it's difficult to distinguish if it's about timescales, but what you're proposing is I would be happy with.
And then I'll just subsume everyone. Does anyone else have any comments on the inquiry session timings? Mr von Spreckelsen?
I don't have anything on the timing specifically. I think your suggestion is actually correct. But what I would say is that I disagree with having the topics bulked into one. Your original assessment of having them individually is what I would consider best. Thank you.
Mr Ferguson, I don't think you commented on combining the sessions. In your experience, does that help? Or?
Again, ma'am, I don't have a feel for how close the technical and economic sessions are, but the other inquiry sessions appear to be standalone topics, which I don't think could benefit from being combined. With there's a possible overlap with forestry there, but I don't think the overlap is to an extent that it would justify a separate inquiry session.
Thank you. So, by my calculation, I had 4.5 days, plus 10 days. So, we're looking at possibly 5.5 days. So, it could end up being the same depending on which way I decide to go. Okay. We'll look at that in more detail when we look at the actual dates for the sessions. So, are there any comments on the preferred order of sessions? First, the applicant, Ms. Wilson.
Ma'am, we don't have any comment varying from the order that you have that's set out in the schedule here. And particularly in relation to the inquiry sessions, they seem to be working in a logical way from broader issues down into very specific effects that have received the most significant number of objections, and of course the objection from the Council in terms of the LVIA. So we'd be content to follow the order that you have listed.
Mr. Ferguson.
The order I had in mind broadly follows your order, and my suggestion would be the strategic route selection followed by strategic alternatives, then moving on to the technical justification and the economic justification. The next is an issue which comes up in programming from time to time, whether the policy and legislation sessions should precede or follow the technical evidence sessions. So I have the statutory context and the development plan square bracketed at that stage, and then it would be landscape and visual and the other impact sessions. And again, depending on your view on where policy should best sit, policy could either follow up at the end, followed finally by the conditions session. Thank you.
Okay, well, before we move on to other parties, does Ms. Wilson have any comments on the suggestion from Mr. Ferguson with regard to policy?
Only to the extent that if that was to be followed, and in particular if the policy was to be put at the end, then I think it would be preferable to leave statutory context and national energy policy separate from the suggestion I made earlier that they might be combined with development plan policy, because they are, as you previously noted, ma'am, whole line issues and feed into the other whole line issues.
That would be leave development plan policy to the end, but still have the statutory overall national policy at the beginning. Mr. Ferguson?
I can see the logic in that, ma'am.
Okay, comments from other parties. Mr. Kitching, and this is about the order of the sessions.
As been described, yes, I can see the logic in that, and I would go off that proposal that's been put forward.
And again, I'm speaking to all of the other participants. Any comments on the order of the proposals? Mr. Bunce-Beckleson.
I think you should stick with what you've intended to do, because I think you'll get more information.
Thank you, Mr. Bunce-Beckleson. I'd now like to look at possible dates on which we could hold the hearing and inquiry sessions. In the agenda for this meeting, I ask parties to look at their availability from the 17th of October until the 16th of December 2022. I'd like to complete at least 1 week of sessions before the end of October, with as little as possible in December, given the holiday period. Taking this and the spirit of our guidance note 23 on managing an efficient inquiry process into account, when would parties be available in October and November? And I'll start with the applicants. Ms Wilson.
Thank you, ma'am. Based upon those estimates, Mr Thompson and I thought that if we were to allow for 15 days, would you be sitting 4 days a week? So we're essentially looking for a 4-week slot. Subject to the order of the topics and the availability of the relevant witnesses matching up to those topics, certainly Mr Thompson and I feel that based on our own availability, we could accommodate the last week of October as the commencement. And there's no difficulty with running through the remainder of November, which would then mean that we'll be finishing by the 3rd week of November. I think from a quick glance, the 18th of November, perhaps.
Does that give us any leeway for overrun?
Well, certainly we would prefer to keep a couple of days available the next week, just in case there was any rerun, because then they're marked out and everybody's available.
So that's starting on the 24th of October, ending on the 17th of November, and 21st and 22nd of November for possible overrun. Mr Ferguson, have you any comments on that proposal?
The only date which would be very difficult for the Council is the 2nd to the 8th of November, and that's the date which I indicated previously. I don't think it was at the position statement stage, it was during the first round of queries regarding availability. So that's the one date which would be very difficult to accommodate.
And why is it difficult to accommodate?
I have a holiday booked for that slot.
Could the Council use someone else?
It's possible, but as I anticipated that holidays and other fixed commitments would be of relevance in fixing the timetable. But I simply say that that's the only date which would be difficult.
As I said in our new guidance note, we are being more stern with regard to dates in order to get things moving and not going into December. But I note we have got some flexibility towards the end of November. I'll have a think. But if you could in turn ask the Council if it's possible to have someone to fill in for you for that week, and let me know as soon as you can.
And I mention this only for completeness. I'm sure some of the other participants may mention this, but I am advised that the 17th to the 31st of October is a local holiday. So there may be some availability issues for individuals, but that's not an issue for the Council as such.
I could ask the local community to comment on that as part of their comments, but I have from the 24th to the 28th of October, and from the 1st until the 29th of November, depending on whether the Council can get someone else to fill in for the week of the 2nd to the, was it the 9th of November?
The 8th inclusive.
Okay, Mr Kitching, availability.
Those dates, I can't see any issue with those dates from our point of view. Thank you.
Mr Swift.
Well, I cancelled the holiday in early November because of this, so I'm free.
Thank you, Mr Swift. Mr McLean.
The end of October and the whole of November, I should be able to attend.
Sorry, I should have asked. Is there a holiday in the local area at that time?
It's the school holidays from the 15th to the 30th, it's school half term effectively.
So would that impact on you, Mrs. Moody?
I think I can work around it. I'll try and make sure that I take the leave the first week and then come back. I'm a working mum. I work part-time, but flexibly. I should be able to accommodate with enough notice just about anything.
Well, I intend to get the note of this meeting out within the next 2 weeks, so you should have plenty of notice, hopefully. Mr. Kerr.
No problem with any of the dates.
Those dates are fine for me.
Mr. von Speckelsen.
I have no problem with those dates either. I was wanting to ask, though, is there's an odd chance that I can't make a day, whether I can have a representative on my behalf?
That's not a problem from my point of view, as long as you make known who that person is beforehand.
Absolutely.
Ms. Wilson?
With appropriate notice, ma'am. I wouldn't have thought it would be objectionable.
Would it be possible to ask what appropriate notice is? Is it 1 week, or is it 2 weeks, or is it a month, or is it 2 months?
I'll let you know, Mr. von Speckelsen. Mr. Ferguson? Any comments about Mr. von Speckelsen being represented by someone else?
No, ma'am.
Okay, as set out in our guidance note, I may have to look at imposing dates, but I will set out my final ruling and dates in my note of this meeting. So I propose that we would sit Monday to Thursday, and this will allow for Fridays for travel and also to recover from the 4 days previously. Our party is content that this accommodation is an acceptable location for the inquiry and hearing sessions, provided that it is available.
Yes, ma'am.
Yes, ma'am.
That we're not running into December, we've more of a chance of getting this venue, but the office will investigate that and I will let you know. If it is unavailable for any of the days, can anyone offer an alternative venue within the area? And I'll start with the members of the community first. Mr. Swift.
Can I have a short think, please?
Mr. McLean.
There is the Balmagee Village Hall, but I'm not sure who the administrators are and what the process would be to inquire whether it's available.
Okay, we can look into that. Thank you. Mrs. Moody.
Yeah, not off the top of my head, there are no halls, but if we want the provision of a whole day facility, we might need to consider other hotels.
Mr. Kerr.
A local town hall in New Galloway might be a possibility.
Has it got a room about this size? Or
Yes, they do have.
Mrs. Harrison? Mr. von Speckelsen?
We can accommodate you if it's this sort of number of people, but if it's with audience as well, then no. But we can do it this number of people.
Your premises is?
It's the old Sligari cottages, which have been combined together into a big house. The kitchen area has got a double table, so in a sense, you would be closer together, but the room is about as long as this and about from here to here. So you would get everybody in. It would be a little bit tight, but if you're having to have an emergency, then I could offer it.
Mr. Ferguson.
I don't have any further suggestions, ma'am.
One thought I had was council building. Do you have any committee rooms, or do you know?
I don't know offhand, but I will make inquiries following this.
Ms Wilson, any comments on any of those venues or anything else you can think of?
The village halls and town halls have been used for public consultation purposes, but it's been pointed out to me by Mr Thompson there may be an issue over Wi-Fi availability in those facilities.
Yeah, we definitely will need good Wi-Fi for the next bit because we'll be looking at documents online. Thank you for that. Yes, Mr Ponsfreckles.
If Wi-Fi is important to the room, then I have to take my suggestion away because there's no Wi-Fi.
Thank you for that, Mr Ponsfreckles. Okay, as I said, the office will look into that and we'll get back to you with the appropriate venues. It may mean that we move from one venue to another, but we will try not to have that if we can. Okay. Okay, I would also like to hear parties' views on conducting some of the sessions virtually. This can work well in some cases. While virtual sessions have particular advantages in terms of convenience and avoiding the need to travel, they involve shorter sitting days with more breaks and are reliant on good home and office IT connections. In-person events are more conducive where there are lots of participants. Based on these factors and providing it is consistent with the guidance in place at the time, what are parties' views on running a combination of in-person and virtual sessions for this inquiry? I'll start with the applicant, Ms Wilson.
Ma'am, as far as the applicant's position is concerned, it would be preferable to avoid WebEx or Teams meeting type hearings because of the difficulties in maintaining connections when there are a number of different connections. And we know from today's discussion that as far as the third parties are concerned, we've got quite a number of hearing sessions with up to 8, 9, possibly even 10 participants. So the applicant's position, and also in terms of inquiry efficiency to avoid any difficulties, is that it be dealt with as an in-person procedure so far as possible. But whether or not parties should investigate how they would manage such a session might be advisable in case any participant unfortunately contracts COVID during the occurrence, and it's not wise for everybody to come together.
That was one of what did happen last year when we got into the winter months, which is when we're having this inquiry. So I did want to just raise the point now that if the COVID situation did change, we may have to change how we deal with the inquiry. So it's helpful to have your views, and it's just get people's views at this early stage.
Can I just add one other comment that's just been passed to me? That it may well be that other parties who are participating would want access, and I don't know if there's a policy about this, to hard copy documents. Normally there's a set of documents brought to the inquiry so that people have those, but that would be facilitated if it was in person and one base for the inquiry proceedings.
Yeah, we'll be dealing with hard copies later down the line. Yeah, that's very true. Ferguson.
While virtual hearings and inquiries worked reasonably well as a stopgap, I would agree that in-person sessions would be preferable, but I think it is essential that we do have a backup plan, and a backup plan which could be used at short notice if someone is struck down.
Mr Kitching.
I feel that obviously in-person is better. Using webinar or web connection sessions will be good as a backup, subject to the type used due to ourselves having issues with security settings for certain webinar programs.
And what type would you need?
The issues that we tend to have tend to be more with Zoom rather than anything else. However, MS Teams seems to work just as good, seems to work fine.
I'll just double check with Graham, but we only do Teams. Yeah. Mr Swift.
in person if possible.
Mr McLean.
Yes, COVID notwithstanding, in person would be my preference.
Mrs Moody.
I prefer hybrid options.
In person if possible.
Mrs Harrison.
I also believe the hybrid options are a good option, and from experience locally, we do have pretty good connections. It might just be there's so little use in this region. I don't know about your experience, but from the last 2 years, we have, we don't lose people too often in these things.
And finally, Mr von Spreckels.
If I was to attend virtually from Sligari, there is no proper internet there. So I would have to travel to a location to actually do the internet. That's not a problem. It's just making that point. So in person is definitely preferable, in addition to picking up on the comment of the hard copies. Thank you.
With regard to hybrid sessions, I know we did investigate that in the past. I will double check. Have we got any further with doing hybrid sessions? I.e. we're in the room and you're on the screen. And I'll let you know in the note of the meeting. Okay? Okay, I've noted everyone's comments, which we'll consider further, and will provide my final decision on the methods for each session in my note of this meeting. So moving on to agenda item 8, procedures for the inquiry, including arrangements for the distribution of paperwork. First of all, the written submission procedure. The note of this meeting will set out the further information and representations required, the date by which they are to be supplied, and those parties who should supply them. Responses to the meeting note should be sent to all the parties that the note specifies. A period of 14 days will be allowed for parties to comment on the further information and representations, with copies again being sent to those parties specified in the meeting note. If the note of this meeting is issued week beginning 27th of June, I propose that the response and written submissions for possible hearing sessions on the impact on other nature conservation interests, including ornithology, and intra-connection and intra-KTR effects, should be submitted by the 11th of July, so that's 2 weeks, with any comments by the 25th of July, a further 2 weeks. For all other written submissions, I will ask for a response by the 18th of July, which is 3 weeks, with any comments by the 1st of August, a further 2 weeks. Prior disclosure of case. On the distribution of paperwork, in order to ensure the smooth running of proceedings, parties are required to disclose their case in a structured and consistent manner prior to the hearing and inquiry sessions commencing. It's important that full details of everyone's cases are disclosed in advance of the sessions. That way, all parties can arrive fully prepared. For all hearing sessions, I would require a hearing statement from those participating, which should provide an outline of the case which the party intends to put forward, set out a list of the documents which are to be referred to, and the names of those who are to speak. These should normally be submitted 8 weeks before the start date. For the inquiry sessions, I will require an inquiry statement from those participating, which should provide the particulars of the case which the party intends to put forward, set out a list of the documents which are to be referred to, and specify the witnesses who will give evidence. These should normally be submitted 8 weeks before the start date. Each person giving evidence at the inquiry sessions will then need to lodge a precognition, a written statement of evidence, which should normally run to no more than 2,000 words. I may use my discretion to relax the standard 2,000-word limit where necessary. In that event, summary precognitions will also be requested. Precognitions and summary precognitions should be submitted at least 2 weeks before the start date. All documents, that's any report, plan, published material, photographs, etc., which you seek to rely on for either the hearing or inquiry sessions, should be submitted at least 6 weeks before the start date. The applicant and the council should liaise in producing a draft list of core documents at least 12 weeks before the start date. For any documents already contained within our core document library, hyperlinks to this list should be provided to avoid duplication. Please only provide those documents necessary to support your case. Documents which other parties have not seen should not be attached as appendices to precognitions or additional statements. These documents should be lodged as such in the normal manner, that is, at least 6 weeks before the start date. Finally, something new which I will be asking the main parties to provide is a summary of case. In responding to ministers, reporters must provide a summary of each party's overall case. Closing submissions are a summary of a party's case arising from the inquiry or hearing and are submitted when all the oral procedures are concluded. In our experience, closing submissions tend to focus on the evidence brought out during inquiry or hearing sessions, but do not reflect the entire case. It can therefore often prove difficult and time-consuming for reporters to summarise a party's case, which they have to rely on material from a range of documents, statements, precognitions and closing submissions. It is our view that parties' cases can most efficiently be summarised by the parties themselves. Therefore, each party will be expected to provide a summary of their case after the oral sessions. I would then include this in my final report. The provision of accurate summaries will speed up the time it takes me to write my report and submit it to ministers. I will confirm the dates for the submission of statements, precognitions and documents in my note of this meeting. It will also be necessary for a complete set of the papers to be put on public deposit so that they can be referred to by members of the public. That will have to include all the documentation available to date, including the environmental statement. I would ask that the applicant and the council cooperate in supplying this information. Can the council suggest a suitable location to put the documents?
Again, ma'am, this is something I will follow up swiftly on following today and come back with a suggested venue.
From now on, when circulating papers for the inquiry, it will be necessary to ensure that a copy is placed on deposit. This should be done by sending a hard copy to the council. The council should also ensure that the deposit set of documents are brought to the hearing and inquiry sessions before they begin. Should any COVID-related publication restrictions be in place at the time of the inquiry, alternative arrangements will need to be put in place, which we will advise on. All information submitted will also be posted on our website. Each party taking part in an inquiry or hearing session should send the papers they are lodging to the other parties taking part in the same session, sending a copy to us at the same time and confirming that the exchanges have taken place. Parties should agree between themselves whether to send these to each other in hard copy or electronic form. I will require electronic versions of all inquiry and hearing statements, any additional statements, precognitions and closing submissions. Any photographs, visualisations and maps should be provided in hard copy. All paperwork should be in Word format and preferably sent in an email attachment to the DPEA. Any PDF documents or tabular information should be submitted in a machine-readable format to allow for cutting and pasting. If parties are unable to meet the deadline set for any reason, it's important that they let us know at the earliest opportunity. Moving on to agreed statements. In preparing for the hearing and inquiry sessions, parties will need to consider the scope for agreed statements so that the evidence presented can focus on the relevant matters in dispute. I would be grateful if the parties would consider whether there are any basic facts, data or assumptions which can be agreed in advance to avoid wasting time in preparing cases. I would expect the applicant and the council to produce agreed statements on possible conditions and the relevant policy framework at least. Draft agreed statements and a draft list of conditions should be lodged at least 12 weeks before the start date. Agreed statements should be finalised at least 10 weeks before the start date, with confirmation of parties' positions on the conditions at least 8 weeks before. So will be any comments on the procedures? I'll start with the applicant, Ms Wilson.
No, thank you, ma'am. Those are standard procedures that we're content with.
Mr Ferguson.
I just missed, ma'am, on your last point when you were running through the 12, 10 and 8-week deadlines. I missed the first two, or I wasn't certain of the first two. It would be helpful if you could just recap on those.
Yes, so it was draft agreed statements and a draft list of conditions should be lodged at least 12 weeks before the start date. And then agreed statements should be finalised at least 10 weeks, with the conditions 8 weeks. So you're okay with the other dates? Mr Kitching.
They're okay.
Mr Swift.
I wouldn't know what to object to, so it's all okay.
To have a better look, obviously we have the note of my meeting and then work back from the start date. But if you have any problems, just let us know. Mr McLean.
Yes, that's fine.
Mrs Moody.
That's fine.
Sounds fine.
Mrs Harrison.
That's fine.
Mr von Spreckels.
Great, thank you.
Moving on to agenda item 9, housekeeping matters. With regard to facilities, no lunch or refreshments will be provided for the inquiry. Parties should make their own arrangements for this. I'm aware that there may be issues over matters such as overnight storage, depending on where we are. These can be dealt with once the accommodation is confirmed. Are there any other issues with regard to facilities for the sessions? This was Mr Ferguson. Anyone else? So the in-person hearing and inquiry sessions will start at 10 a.m. daily and finish at around 4:30, with a 1-hour lunch break between 12:30 and 1. There'll be short breaks mid-morning and mid-afternoon. Depending on progress, the start time may be brought forward to 9:30 and the finish time may also be extended. Virtual sessions would normally start at 10 a.m. and consist of around 2 2-hour periods each day, with a suitable lunch break of at least an hour. So agenda item 10, site inspections. Given the timing of the inquiry in the winter months, I propose that the majority of both my accompanied and unaccompanied site inspections will take place before the inquiry in August-September. To help me with this, I would ask the applicant and the council to liaise and provide me with a list and map of those viewpoints from which they wish me to see the proposal, both accompanied and unaccompanied, within 4 weeks of today's date. This should be made available for other parties' comments, and I may add to the list. The accompanied site inspections will involve any properties or locations where I need permission to gain entry to the land. I propose to carry out the rest of the site visits unaccompanied. For the unaccompanied inspections, where the viewpoint chosen for a site visit is not on or close to a road, parties should provide me with details of where it is possible to park and a map of the most appropriate route from there to the viewpoint. Any comments? Ms Wilson. Mr Ferguson? No. Any other parties wish to comment? Any queries parties may have about the inquiry should be directed in the first instance to the case officer, Liz Kerr. Her telephone, postal and email details will be included in the note of this meeting. So just to confirm, I shall prepare a note of the matters arising from this meeting. I will arrange to have it sent to all of those who have attended and provided their contact details or have expressed an interest in being kept informed about the proposal. It will also be available on our website. The note will include details of the procedures that we will follow and those parties being invited to participate. It will act as the formal procedure notice for the inquiry. So are there any other issues which parties wish to raise about the procedures before and during the inquiry? Ms Wilson.
Just one matter, ma'am, in relation to procedures before the inquiry. You'll be aware from the letter from the email from Mr Thompson beforehand that the applicant has serious concerns as regards the lack of specification as to the forthcoming scope or content of the Council's case. Leaving aside the reasons for that and how we got to this situation, to avoid any prejudice and to particularly assist the applicant to press on with preparation of their evidence, it would be extremely helpful to have an indication from the Council as soon as possible. And if Mr Ferguson could consider giving an undertaking as to when that will be, so that that can be anticipated.
Mr Ferguson.
As my email response explained, we now have delegations in place which will allow certain clarifications to be provided, but the scope of the Council's participation in the inquiry is, in the various sessions as we've discussed, is beyond what my instructions originally were. So those are topics beyond the Council's reason for objection, and I will need to take instructions and develop the Council's position on those. But in relation to landscape and visual, which is at the core of the Council's original objection, I will provide the clarification on whether or not the Council's objection extends to the 5 applications, which was a clarification sought by the applicant, and also whether the reason for refusal applies equally to all 5. And I would hope to be able to provide those clarifications within 10 days from today. But beyond that, I'm not sure what further clarification Ms Wilson was referring to, or if it's limited to those subjects, with the Council's position being developed through hearing, inquiry statements and so on.
Ms Wilson, would that be 10 days' time? Would that provide you with enough clarification, or you need further clarification?
Certainly in relation to landscape and visual and the Council's position in relation to each of the 5 applications, and whether or not the reasons presented to the ECU are being adhered to, that would be helpful to have it within those 10 days. I don't think it's consistent with the principle of prior disclosure for the applicants to find out the Council's position on other topics that aren't covered by the objection when they first see hearing statements or inquiry statements. There should be advance notice of that and ahead of the deadlines for those statements having to be produced.
Mr Ferguson.
A number of topics are related to the landscape and visual objections, such as policy and so on. And as I mentioned in my note, I would not regard that as an expansion in any way of the Council's case. Consideration of those topics is a natural consequence of the objection. But in relation to the further sessions, which I think you have requested the Council to participate in all of these sessions, and a number of these topics were not covered even in the officer's assessment. So as we sit here today, I don't have a feel for how long it will take for the Council to reach a position on those. But I will undertake to investigate that. But it may be difficult. I will go no further than that. But it may be difficult for the Council to in effect have a pre-hearing statement on these topics. But I will look into that.
Yes, from my point of view, it would be really helpful, because obviously the note of the meeting, I am inviting you to, as you say, most of the topics, if not all. So I need to know, A, that you're going to come and how you see your role within those sessions. You said 10 days for the landscape and visual. If we say 2 weeks, let me see, 2 weeks for an assessment of all. Obviously, you know which sessions I'm going to invite you to now. You don't have to wait for the note of the meeting. So 2 weeks to comment on the rest.
I suppose the question for you, ma'am, is whether you are inviting the council to participate, or whether you are requiring or strongly inviting the council to participate, and the council's response will depend whether it's an open invitation to participate or a requirement.
At the moment, it's a requirement.
That's what I understood from the initial discussion, but a few moments ago you mentioned the council responding whether or not it intends to participate in the various sessions.
Yeah, that was a miss. It's how they intend to participate.
Fine. That's what I understood from the earlier discussion, and I don't know whether 2 weeks is going to be sufficient, but what I can do is establish within the original 10 days whether or not, well, what it is that the council can produce. Because if, for example, the council is providing a written position on cultural heritage, I just don't know the process for that and the availability of staff to cover that. But I can establish within the 10 days what the process would be for that.
Yeah, as soon as you can, preferably within 2 weeks, and 10 days for the landscape and visual. Ms Wilson?
I'm obliged, ma'am, for that.
Any other matters that anyone wants to raise at this point in time? Is everyone clear on what happens next? So finally, I'd like to thank everyone for the participation today, and I now formally close this meeting. A last reminder to everyone to please fill in the attendance sheet before you leave, and I wish everyone a safe journey home. Thank you.